posted under the head orders at D.27.28.2025, Your Lordship. It may be taken at 4 p.m. as first case. The executing court is proceeding with the execution procedure, whereas the respondents are willfully not appearing in the second appeal. The appeal has been admitted in the year 2019 until date. Galatnama has been filed on behalf of the respondent.
Why is it listed for orders?
Your Lordship, because I have filed an IF for substituted mode of service through the executing court that is through Order 3, Rule 5 of the CPC. And for an interim stay of
the service is not complete.
Service.
Otherwise,
Your Lordship, the original respondent was substituted by this honorable court. The service is complete on 1A, B, and D. Only 1C has not been served the notice because of insufficient evidence. And the same respondents have been substituted in the executing court.
already substituted.
Already substituted.
Come at 4 o'clock. Inka 5 nikalenge.
Okay.
35.
And nobody is appealing for the respondent?
Nobody.
Serial number 1, in supplementary list counsel. Senior counsel from outside had come in. Since there is a matter.
Okay, fine. Where is the other seat?
Other side will.
First I have to dictate the judgment. First I will dictate the judgment and then.
They how much?
This case from supplementary list item 2, second appeal 25 of 1996.
क्लियरेंस के हिसाब से रिपोर्ट कर देंगे. is your duty. We'll work here only. Second appeal number 25 of 1996 within bracket R. This appeal has been filed against the judgment dated 5/12/1995 within bracket decree signed on 12/12/1995 bracket means passed in technical appeal number 55 of 1991 by learned additional district judge Kulla, confirming the judgment in decree dated 24/8/1991 passed in technical number 140 of 1988/23 of 1984 passed by the Munsif at Kulla. The suit was dismissed and the first appeal arising out of the suit was also dismissed. Consequently, the plaintiffs are the appellant before this court. ध्यान देंगे आप? ध्यान देंगे? This appeal was admitted for final hearing. By order dated 23/1997, while framing only one substantial question of law. And it was also observed that any other substantial question of law may be raised at the time of hearing of the appeal. When the matter was taken up on 14/8/2025, two additional substantial questions of law were framed after hearing the parties. Consequently, this appeal consequently, three substantial questions of law have been framed, which are as follows. The learned counsel for the appellant at the threshold has submitted that if the second substantial question of law is answered in favor of the appellant, then the matter is required to be remanded to the first appellate court for passing appropriate judgment in accordance with Order 41/31 of CPC. And in such circumstances, the other two substantial questions of law need not be answered. The learned counsel, by referring to the judgment passed by the learned first appellate court, has submitted that the judgment is running into 7 paragraphs. The first paragraph deals with the submission of the appellant. The second paragraph deals with the submission of the defendant. and the issues framed by the learned trial court. The third paragraph deals with the submission of the appellants assailing the judgment of the learned trial court. The fourth paragraph deals with the submission of the respondents supporting the judgment of the learned trial court. And the sixth paragraph partly records certain findings and partly it contains submissions.
The Jamindari receipts M1 which is not the executed document.
And the findings is recorded in paragraph 7 of the implement judgment passed by the learned first appellate court. The learned counsel has submitted that while deciding the point of adverse possession in paragraph 6, Zamindari M form has been taken into consideration, which was never exhibited before the court. The learned counsel has also submitted that there is no discussion of oral evidence at all,
Oral and documentary evidence.
or oral and the documentary evidences which were exhibited before the learned trial court. We have submitted that the matter also related to adverse possession which required appreciation of pleadings of the respective parties and the evidences adduced in connection therewith, both oral and documentary. The learned counsel has also submitted that claims and counterclaims were made on basis of certain registered documents, including one gift deed and one sale deed.
Same.
He has submitted that he has referred to the judgment passed by Honorable Supreme Court
2022 3 SSC page 90. Manjula Devi.
in the case of Manjula and others versus Shyam Sundar and others reported in bracket 2022 bracket close 3 SSC 90.
Para it relevant now.
And has referred to paragraph 8 thereof, and he submits that it has been held that the first appeal is a continuation of the original proceedings, and the appellate court's jurisdiction involves rehearing on appeal on questions of law as well as facts. And the judgment of the appellate court must reflect conscious application of mind and must record findings supported by reasons on all issues put forth and pressed by the parties. The learned counsel submits that neither the learned First Appellate Court has pronounced on all the issues, nor any point of determination was framed by the learned court, nor the materials on record have been discussed. And therefore, the mandate of Order 41/31 of CPC has not been followed. Yes. Then referred to the judgment passed by Honorable Supreme Court,
2021 10 SSC page
reported
777.
in bracket 2021, volume 10 SSC 777, bracket K. Karpur Raj versus N. Ganeshan, and has referred to paragraph 7 thereof to submit that the entire evidences on record are required to be considered even when the First Appellate Court has to arrive at concurrent findings. The learned counsel submits that the second substantial question of law be answered in favor of the appellant, and the matter be remanded to the learned court for fresh consideration on the basis of the materials already available on record. And so far as others two substantial questions of law are concerned, the same may be left open for consideration by the learned First Appellate Court, as those will also involve appreciation of both fact and law based on materials on record. The learned counsel appearing in view of the aforesaid submissions, the learned counsel for the respondents have been called upon to respond to the arguments of the counsel for the appellant so far as the second substantial question of law is concerned. The learned counsel has submitted that the learned counsel for the respondents has submitted that the length of the order will not decide its substance. We have submitted that the learned First Appellate Court has done the needful, and once the trial court judgment is to be upheld, there is no requirement to deal with each and every aspect of the matter. The learned counsel has submitted that the very basis of the claim of the plaintiff was not sustainable in the eyes of law. He has also submitted that the adverse possession finding of adverse possession has already been recorded by both the courts in favor of the defendants. The learned counsel has relied upon a judgment passed by Honorable Supreme Court, reported in AIR 1967 SC 1124, equivalent 1966 SCC online SC 236, and has referred to paragraph 13 of the said judgment. And he submits that the Honorable Supreme Court observed that it was true that the High Court did not enter upon a reappraisal of the evidence, but it generally approved of the reasons adduced by the trial court in support of its conclusion. And therefore, the Honorable Supreme Court was unable to hold that the learned judges of the High Court did not consider the evidence. It has also been held that it is not the duty of the appellate court, when it agrees with the view of the trial court on the evidence, either to restate the effect of the evidence or to reiterate the reasons given by the trial court. Expression of general agreement with reasons given by the court decision which is under appeal would ordinarily suffice. Paragraph 13 of the aforesaid judgment is quoted as under. इनका भी दोनों का पैराग्राफ कोट कर लेंगे, दो जजमेंट साइड हैं एट एप्रोप्रिएट स्टेज चेक करें. However, during the course of argument, it is not in dispute that no point of determination has been framed by the learned first appellate court, and finding of adverse possession has been recorded primarily by referring to Zamindari M form, which was not exhibited. M form as such was not exhibited. Zamindari M form, which was not exhibited. Sorry? Not exhibited. After hearing the learned counsel for the parties, this court finds that a suit was filed by the plaintiff seeking declaration of right, title and interest over the suit land and for confirmation of their possession. In the alternatively, it was prayed that if the plaintiffs are found not in possession, then a decree for delivery of possession be passed in their favor. Trial court का judgment से para 2 and 3 case of the plaintiff. 2, 3 and 4. Written statement was filed by some of the defendants, and the plaintiff amended the plaint and got the name of Santu Singh, Ugan Singh, Benedict Toko and Edward Munda added as defendant number 5, 6, 7 and 8. The defendant number 1, 2 and 3 filed a joint written statement, and defendant number 5 and 6 filed another written statement jointly, and defendant number 7 and 8 also filed separate written statements. However, so far as defendant number 4, who was the Deputy Commissioner Gumla, was not represented, the defendant number 1, 2, 3, 5, 6, 7 and 8 had denied the claim of the plaintiff and raised a plea that the suit was not maintainable. It was barred by law of limitation, waiver, recusance, estoppel and adverse possession, and it was bad for non-joinder and misjoinder of necessary parties. The further case pleaded by the defendants, ये पैरा 7 है, पैरा 7 कोट करेंगे, ठीक है? 7 and 8 इसको हम कोट करेंगे. The learned trial court framed the following issues for consideration. पैरा 10 में है. Issue number 3 was decided in favor of the plaintiff and against the defendants. The issue number 5 and 6 were taken up together. The court recorded that the plaintiff examined altogether 9 witnesses. And the defendants examined altogether 17 witnesses. Documentary evidences were also adduced on behalf of both the parties. The plaintiff the learned court, while deciding issue number 5 and 6, also held that the deed of partition was between Titenga Sahu and Rodna Sahu, so it was held to be not binding against the defendants. The learned trial court ultimately held in paragraph 24 capital A as under. And both the issues were, issue number 5 and 6 were decided against the plaintiff and in favor of the defendants. So far as issue number 4 is concerned, the plea of adverse possession was decided in favor of the defendants by paragraph 25, which is quoted as under. And ultimately, while deciding issue number 1, 2 and 7, the learned trial court held that the plaintiff had no cause of action and ultimately dismissed the suit against. Before the learned first appellate court, the arguments of the parties as recorded reveal that many points were raised, both on question of fact and law. However, the learned first appellate court recorded the finding partly in paragraph 6 and 7 as follows. Quote करेंगे. Mark. This court finds that the first appellate court has not framed any point for determination for consideration. Further, the learned first appellate court has not considered the oral evidence at all, and some of the and most of the documentary evidences have not been considered. Documentary evidence में तो कुछ भी नहीं. And oral and documentary evidences placed on record by the parties. This court also finds that this court is of the considered view that the first appellate court, being the last court of being a court of fact and law, every aspect of the matter and the materials on record were to be considered by the court. In order to come to a definite finding. Moreover, the first appellate court has taken into consideration zamindari M form, which has not been exhibited before the court. This court is of the considered view that the judgment of the first appellate court cannot be said to be in conformity with the provisions of Order 41, Rule 31 of CPC. This court is of the view that even if the first appellate court has to arrive at concurrent findings, still the materials on record is required to be discussed. And then the court has the jurisdiction to reaffirm or affirm the findings of the learned faculty. But such exercise has not been done by the learned first appellate court in the instant case. While deciding the fact also remains that while deciding the point of adverse possession, the pleadings of the parties along with the materials placed on record has to be carefully scrutinized, and certainly such a finding would depend on both oral and documentary evidences based on record. But even that exercise has not been done other than the first appellate by returning of opinion. In view of the fact that this court has come to a conclusion that the learned first appellate court has not done the needful while exercise its jurisdiction under Order 41/31 of the CPC, the matter is required to be remitted to the first appellate court for fresh consideration on the basis of materials already available on record and in accordance with law. Since the second substantial question of law is answered in favor of the appellant, this court is not inclined to enter into the other two substantial questions of law, which are also required to be considered by the learned first appellate court based on evidences placed on record. Accordingly, the impugned judgment passed by the learned first appellate court is hereby set aside only on the ground of non-compliance of the provisions of Order 41/31 of CPC, and the matter is remitted to the concerned court. The parties to appear before the concerned court on when will you appear?
Sir,
Yes. Any suitable date for appearance? आप बताइए 2 महीना बाद का डेट देते हैं? Yes. Third of November. 3rd of November at 11 a.m. एक तो जजमेंट हम लोग लिए ऑर्डर 41/31 का दोहराने से बोलिए ठीक है ना, उसमें हम लोग थोड़ा लिखे हैं एवरीथिंग हैज बीन रिटन। आप भी किया है ना एक जजमेंट, एक कॉन्करेंट फाइंडिंग कर दी, 2-3 है रिवर्सल पर, एक कॉन्करेंट फाइंडिंग। पार्टीज टू कोऑपरेट। टाइटल सूट कब का है?
84.
Title suit, since the title suit is of the year 1984, the parties will cooperate with the
The
expedition.
time is 6 Lord equal fine.
ऐसा नहीं फिक्स कर सकते, ऐसा नहीं फिक्स कर सकते। अभी तो नहीं पता, कोई पार्टी को मन करे सुप्रीम कोर्ट जाने का, बहुत तरह का ऐसे।
Item 1 from supplementary list second appeal 261 of 2003.
Yes. Appellant. What is the substantial question of law?
Judgment and decree of the lower appellate court is illegal or unconstitutional. No discussion of the ordinance general है खास to
Order 41/31 ही है, वही है ना? वही। Appellate court has done the needful or they have not done the needful?
appellate court has concurred, trial court जो किया है उसको concur किया है. It's not case of
Point for determination frame किया.
ये तो किया. वो सारा किया.
हाँ,
Make me I'm obliged for the accommodation given. Now,
I must make it very clear to you, if the substantial question of law is answered
Madam,
in your favor,
madam,
we will only remand the matter. We will only remand the matter,
that because there are two reasons.
provided we agree with you and subject to what they have.
It is a case of remand because of more than one reason. My lordship
Kindly
can-
argue in your own manner, I
Yes.
just indicate.
Now, the question of law framed my lord has already seen whether the judgment and decree of the lower appellate court. I'm reading from my notes only because I saw the records. The records are also not very clear, very free. My other side can verify wherever.
Copy has not
No, from the records you can verify. I'm agreeing. Now, the question is whether the judgment and decree of the lower appellate court is illegal and against the judicial authority for non-consideration and non-discussion of the evidence on the court. Now, my lordship, can you see from the plaint, and I have quoted here, it can verify by my friend, the relief rate for each A. Firstly, my lordship, can you see that this suit has been filed by none else but adopted father and mother, and the date of registered adoption according to this case is 5th of May 1976.
The adoptive parents have filed it.
Yes, that is the beauty of the case. I'm coming to that. Adoptive parents, father and mother both have filed. Plaintiff number 1 is the adoptive father, plaintiff number 2 is the adoptive mother. And the registered deed is, according to them, was on 5th of May 1976. This is most important because within 2 years, the suit had been filed on 12th of April 1978. So, only within 24 months it has been filed. Now, kindly see the relief I have quoted here. A is declaration that defendant number 3 is not adopted son of the plaintiff, and there was never any adoption of defendant number 3 by the plaintiff, and for cancellation of the deed number so and so, dated 5th of May 1976, registered at Deoghar Sub-Registry Office purporting to record alleged adoption of defendant number 3. Now kindly see relief number 2. Relief number 2, declaration of plaintiff's title to the suit properties described in Schedule A of the plaint and recovery of possession of the same through court. This relief I submit, my lord, that neither the trial court nor the appellate court has either considered or rejected. This relief has not been considered. This itself shows that both the judgments are both the courts did not consider even the relief prayed for. The first relief has been considered, discussed, I will show how, but the second relief has not been considered at all. And then the third relief was future mean profit from the date of suit till recovery of possession. This relief has also not been considered because the second relief has not been considered. The third goes automatically. Now kindly see the case. In this case, firstly, before going to the details of the fact, I like to attract my lord's attention on a subject which fell from my lords on the other day also, that in a registered deed, normally any registered deed can be rebutted by suitable evidence. So far as the adoption is concerned, there are two specific provisions in the Act itself. Firstly, that a deed of adoption registered carries a presumption rebuttability. Section 16. I don't need to repeat it. And then, in a suit for adoption or cancellation of adoption, the onus of proving the adoption lies on the person who alleges adoption. I may not be plaintiff, I may not be defendant.
No, but if it is a registered deed, the onus is differently placed.
That is what I'm trying to show. For my lordship, can you see section 12?
Maybe adoption. The adoption deed was upheld.
Okay. By trial court and appellate court upheld it without discussing, without considering, nothing. It has done it only mechanically.
How this adoption is related to title?
Because our case was in the plaintiff itself that I was an old man and the plaintiff number one had a bad habit of drinking. Due to that, he came in the company of defendant number one, and he was old man, not able to cultivate his lands. He had no means to cultivate. Therefore, these are the lands, non-sellable lands of SPT Act. Santhapra is non-sellable land. So I entrusted my land to the defendant number one for cultivation, and for that he insisted on a execution of a registered deed of entrustment. For that purpose only, I was taken to the court. And in that garb, they got this deed registered, and then I handed over my land to him.
So you are alleging fraud?
Yes. And in the first year, products from the lands were given to me, so I did not raise any hue and cry. In the second year, when they thought that's it, now everything is over, they refused giving me the product, and then only I could know that he had fraudulently got a deed registered, and therefore I wanted to get possession, recovery of possession and title of the land. So far as title is concerned, admittedly the lands are non-sellable. So the title cannot divest in anybody by execution of any deed. Adoption deed also.
Adoption deed will not confer title. Adoption deed is only meant for adoption.
Exactly, madam.
Does it confer title also?
No.
No.
Exactly, and that is what I wanted to submit. And then in the plaint, I have specifically.
Does the adoption deed mention about the date of adoption, the ceremonies performed, anything mentioned? What is that exhibit?
Exhibit B is the deed of.
Exhibit B
हमारे पास तो और
Exhibit B की exhibit D.
Exhibit B, I'm sorry, a very short copy my friend has got.
नहीं कॉपी नहीं है ये तो हम पढ़ नहीं सकते अपने मित्र को कहे कि कैसा कॉपी आपने
And my friend other side, both of us originally practiced in Patna High Court. So अब रिकॉर्ड हुजूर इतना गंदा है कि हम तो इंस्पेक्शन में जब थोड़ी देर टाइम लगा तो देख रहे थे आपके पास जो कॉपी है वो भी वर्क नहीं करता है।
Exhibit B.
सभी एविडेंस जो साइन है हमारा कॉपी कम पर ही नहीं। सब ऐसे ही हिसाब से लिखा गया जो कोई पढ़ न सके, न वकील साहब न जज साहब।
Appellate
That
court-
everything will be clear from the evidence of the defendant number one.
We are not on merits right now. We just want to see that what were
Alright.
the issues framed,
Alright.
how was it decided by the trial
Yes,
court,
yes,
and
yes.
how the first appellate court has
Then
considered.
kindly see the issues are.
It's the first.
Find at page 5 of the appellate court judgment. Page
No,
5
first
of
we will see the trial court judgment.
appellate court judgment.
First
Appellate-
trial court.
नहीं ट्रायल कोर्ट ही appellate कोर्ट ही ट्रायल कोर्ट का मेंशन किया है देयर आफ्टर इट हैज
हाँ, my
कोई
friend
बात
is
नहीं, पहले ट्रायल कोर्ट देखते हैं। उनको बहस करने दीजिए, अभी आपकी कोई रिक्वायरमेंट नहीं है।
Trial court का judgment to you.
खाली असिस्ट करते
No, my friend is right because the Indian appellate court has quoted it and that is a typed copy. So you it may be convenient for my.
ट्रायल कोर्ट तो हिंदी में है,
Trial-
हिंदी में कोर्ट किया हुआ है।
ट्रायल कोर्ट का हिंदी appellate कोर्ट का हिंदी देखा जैसे
नहीं, appellate कोर्ट का हिंदी में है। Appellate court judgment is in Hindi.
हाँ that is
Trial court में हुई हो I have got a typed copy of the judgment of the trial court. But it is at page 9 of the trial court. Page 9. Page 9, number 1. Whether the suit as framed is maintainable. Number 2. Whether the plaintiff has got a valid cause of action for the suit. 3. Whether Sulkant Manjhi is the legally and validly adopted son of Gulab Rao and Kula Rao, plaintiff number 1 and 2.
Yes, all 10 issues were framed.
10. Yes. Okay. Sorry? 10. Then 4. Whether Gulab Rao and Kula Rao were the victims of fraud and misrepresentation played by Balesar Majhi and whether deed number 94 of 1976 is the result of such farji and such forgery and misrepresentation. Then 5. Whether civil court has jurisdiction to try the suit in view of the issuance of notification of section 9 of regulation 3 of 1972. I'm sorry. It is not true. Whether the suit is bad for non-joinder of the particular formal issue, whether the suit is bad under law of limitation, no. Whether adoption deed number 94 dated so and so executed by Gulab Rao and Fuller of 9 and registered at the Devghar Registry Office for taking Sulkant Manjhi in adoption by the natural father and mother in giving adoption is a valid, genuine and legal document. Whether the plaintiff is entitled to a decree as paid for. Then whether the plaintiff is entitled to any. So, with regard to prayer number 2 in the plain which I have placed before my Lord, there is no issue. Therefore, there is no question of considering that. other most of the things are very clearly quoted in the claim, in this judgment. I can take help from the judgment itself.
The Purohit has been examined, correct?
Has been examined and has denied it. Mother, we can
And
see.
There are 9 witnesses who have given the evidence on handing over and taking over of the child.
One thing I will permit it. Purohit has been named by the plaintiff. He has appeared and Napit has been named, denied, and same name has been stated by defendant number 1 who has been examined as DW16. He said that he was the Purohit, but he was dead.
He was?
He was dead. That is the, your loss is right that giving and taking is the most essential part of the ceremony as a whole. And that home is a sign qua non, as the Honorable Supreme Court has said in so many judgments. Take this point alone. Purohit has been examined on behalf of the plaintiff. My friend, the learned trial court has quoted it.
What about the learned first appellate?
What do you mean?
First appellate.
First, absolutely.
अपील में इन्होंने क्या किया देखते हैं.
अपील में हुजूर देखा जाए ये है जो टाइप है हिंदी में है.
ये सब तो कहानी है. पैरा नंबर 3 तक तो सब
इसमें
कहानी
पहला
है.
तो ये है कि
पैरा नंबर 5 तक तो सारा वही है.
इनका पेज 5
पैरा
पर
7
हुजूर इन्होंने कोट कर दिया है ट्रायल कोर्ट की इशू को.
ठीक.
उसके बाद
दोनों ने अपने लिखित बहस भी प्रस्तुत किया है.
जी, इन्होंने कोई पॉइंट ऑफ क्वेश्चन
पैरा नंबर 7 में उनका तर्क है.
अभिलाषी के अधिवक्ता के मुख्य तर्क किया है. हुजूर मैं नहीं कहना था कि इन्होंने कहीं ये भी पॉइंट तय नहीं किया कि किस पॉइंट पर फैसला देना है. They have not framed any question for the appellate. I mean, this itself shows hardly the appellate court has applied its mind. More or less judicial. And I will show how the evidence, how the things are there.
Exhibit निकालिए तो Exhibit B. The learned appellate court has taken into consideration.
Yes.
देखिए, ठीक है, point of determination
Right.
but the core issue was the point of adoption.
Yes,
That has been considered.
that has been considered. You're right.
That has been considered, and the ground which the appellate court has taken is that if your story is believed, then what was the occasion for the natural parents to go to the registry office?
Yes, that I have explained. I had gone there. That is in the plaintiff itself. This is what I submitted.
Who had gone there?
The plaintiff.
The plaintiff
Plaintiff
had
had
gone there
said-
for the purposes of executing some other document.
Yes.
What was that document and what was the occasion
That
for the
document was a document of entrustment. That is-
entrustment to whom?
No, it is my land.
And
I
you were
entrust-
entrusting to whom?
Defendant number one.
Defendant number
I
one.
entrusted my land. That is clearly stated in
right.
the plain.
You were entrusting the property to defendant number one.
One for cultivation only because it is non-sellable land. It can't be sold.
Who was defendant number two?
Defendant number one,
Who was defendant number two?
the father and mother, natural father and mother.
The defendant number two was mother.
Yes.
The court says that if then where was the occasion for the defendant number two to go to the registry office and put her signature?
The plaintiff is an illiterate person, admittedly. I'm
Illiteracy
not
का
aware
कोई
of the,
excuse है क्या?
I am not aware of those proceedings. And in Santhal Pargana SPT Act, all these lands are non-transferable. Therefore, nothing can be done. The only way of transfer.
We are focusing on the core issue, that is the deed of adoption.
Right.
Right?
That is what. So far, deed is concerned, there are two services. Firstly, the deed of adoption was forged and fraudulent, number one. Number two, I had gone for a different purpose. I was taken for a different purpose. I had signed. I am an eligible man. It is
Both
not.
of you had signed.
Pardon?
What was the occasion for the lady to
That
sign?
is what they say according to my.
No, it must be there in the deed. They say means what?
Deed is such a dirty. I have not.
It must be there in the deed that mother is also signing.
But the taking over and handing over has not been proved. That is what I am on that. The Honorable Supreme Court has said that Datta home is assigned to a nun for adoption. It has not been proved. Only the state deed will not do.
आपका जो ये एपलेट कोर्ट का फाइंडिंग है, there is no discussion of any oral evidence.
Whatever.
There is no discussion of any oral evidence.
No. And from oral evidence, they have not proved. the giving and taking ceremony. Rather, the trial court has said that yes, plaintiff has given only negative evidence. I was with a negative cause that no adoption was there, so I will give only that evidence which will show that no evidence was there, though no adoption was there. It was for the defendant to show that no, there was adoption. And from the evidence of defendant number 1 has been examined at DW 16, I will show that there was no giving and taking. The first question, the most important question which is considered for adoption, is that there was no function, there was no giving and taking. Admitted, he has admitted that yes, so and so was his Purohit, but he is dead. But the fact is that the Purohit was examined, same person, the name has common. My Purohit's name has been admitted by the defendant number 1. My Purohit appeared in the court. My barber appeared in the court. Defendant has admitted that yes, they were the Purohits and barber who had taken part in the adoption ceremony. But they are dead, therefore they cannot be examined. That is what he says. And they were already examined, perhaps he forgot it. The main crux is here. Kindly see that thereafter. Because
Where is the discussion of the learned trial court?
my God. Is there evidence?
No,
Yes.
yes. Where is the discussion of
Yes,
evidence
just
for the
one.
learned trial court?
Firstly, he quotes the statement in the plain, then WS.
Issue number 8, straight away, page number 10.
Just 1 minute. My lord, I'm sorry, issue number 8, page 10. Madam. Page
Issue number 8.
Page 10.
Page 10 में issue number 8.
ये नहीं हाँ पेज 10 में तो हुजूर इशू है एक ना
ये हमारे इसमें तो एक पेज नंबर 29 है, एक पेज नंबर 30 है, एक पेज नंबर 10 है. मेरे कॉपी में 3 पेज नंबर्स आते हैं. इशू नंबर 8 देखिए,
इशू नंबर 8
ट्रायल कोर्ट.
yes exactly exactly this is what I wanted to point out. Kindly see issue number 8. There is a specific pleading in the plaintiff and the defendant's case of the plaintiff and I'm sorry, I stand corrected. My friend is my old friend. The case of the plaintiff is that the present suit was originally filed by the plaintiff Gulab Rao and his wife Phulo Rao that during the pendency of the suit, the former died and the latter alone contested the suit, and the suit was filed for declaration that defendant number 3 was never adopted by the plaintiff, and I skip this paragraph, my lord. Then, according to the learned counsel for the plaintiff, the main dispute is regarding adoption in the plain. The complete denial about the adoption that so and so, it has further submitted on behalf of the plaintiff that plaintiff has no natural issue. I skip it, my lord. My lord, yes. Kindly see page 11 from the top. The child, such circumstances, any adoption by them is naturally expected to be well proclaimed in his locality amongst the customer, friends, relations, family, priests, barber, and other is prevalent in the village. Pichi alias Pichi Duku, and also so and so Chattis of Devghat town. Of course, where is that? I lived in this Mohalla Chattis of Devghat town. Chattis is the predominating inhabitual by Dhani. The plaintiffs are of Dhani caste, which the plaintiff belongs, and there are 36 houses for the said caste there. Apart from that, they have relation in the village Pichi. They have their Purohit of Pichi and also Rohini. Because the plaintiff had inherited the properties from paternal and maternal side, so the family priests of both sides are attached to the plaintiff. It is further been argued on behalf of the plaintiff that the defendants claim inter-caste adoption by belonging Jadav caste. It is admitted that under the law, there is no caste bar in adoption, but the plaintiff asserted that the traditional bound caste dominated society of people, such relationship is confined. I can just skip it below. In the next paragraph, according to the here, my lord, the very important thing is here, in the middle of the page. According to the learned lawyer for the plaintiff,
Yes.
that according to PW1 is the plaintiff who पढ़ा देना कोई छोटा बच्चा या बता दिया हमको कोई plaintiff who clearly denied adoption ceremony of any kind at her residence. PW2 is her uncle. Now all his relations are there. PW2 is her uncle, law who also denies the adoption ceremony. PW3 was Mukhia and head man of the village who has denied the adoption. PW4, some name is there, whose house the Chatisi is alleged to be the venue of adoption, but flatly denied. The person in whose house it is alleged to have taken place, he has also denied it. I lived in a rented house. At his house, he is the son of late Pratima Devi. देखा जाए कि Pratima Devi की आया है. This is admitted. I will show from the evidence of DW16, defendant number 1. Pratima Devi was my owner of the house. Her son has come and said that no adoption has taken place in the house. In the above house, plaintiff were tenants during the event period of 1973. PW6 is the family barber. Family barber of the plaintiff at Pichi. PW6 is Jharkhand Pandey. This name has been taken by the defendant also, admitted. Jharkhand Pandey of so and so, who alleged by the defendants to be the priest, but denied by the plaintiff and also the witnesses himself. He also denies the alleged adoption. The Purohit also denies, and Donis have defined to be a casual witness in Exhibit E. As
What is Exhibit E?
I will see.
What is Exhibit E?
Press the photograph.
आगे फाइंडिंग क्या दिया है बताइए।
जी उसी पर इसमें एक दो तीन लाइन को
हाँ।
और देखिए ये उसमें नीचे तीन लाइन है PW9 is the family priest of the plaintiff and this fact is mentioned in the plaint also. He also denied the knowledge, information or invitation regarding the alleged adoption. Now, among the DWs, अब हुजूर देखा जाए DWs का कंसिडरेशन करते हैं इसमें हम दिखा देते हैं कि अब ये जो कहा है सब admitted है by DW16 none else but defendant number 1 himself. DW सबसे पहले तो हुजूर को भी है कि इनके गवाह में 6 एडवोकेट क्लर्क हैं DW 1, 2, 3 and 4 are एडवोकेट क्लर्क यहाँ 4 है 2 और आगे आ जाएंगे एडवोकेट क्लर्क and are almost formal witnesses, except DW3, who claims to have identified. But he has admitted that the cause only for the fixation was not present when the deed was drafted. PW6 is the deed writer. DW6 is the brother. DW7 is the Bhagna. DW8 is the Gotia. DW12 is Sala. DW12 is also important. He is Sala of
हाँ
the
बताइए respondent.
एक
Is
second.
there any discussion of any oral evidence in the appellate court's judgment?
Of course not,
Any discussion of any oral evidence? Because the trial court has taken that it is an unimpeachable document. Registered deed is only a presumption.
certainly
It is not
presumption.
a, आप देखिए
जो
appellate-
इन्होंने just हम उनको कुछ बात दिखला देते
हाँ,
हैं
बिल्कुल, बिल्कुल।
मेरे मित्र ने जो सबमिट किया है प्लेंट लाइए प्लेंट जब सब प्लेंट पढ़ देते हैं
With my Lord's permission, 1 minute more. Only thing DW16 कोई नहीं है DW1 डिफेंड नंबर 1 है खाली उसका एविडेंस हुजूर पढ़वा लिया जाए सारा बात हमारा एक्सेप्टेड है और उनका खुद का बात कंट्राडिक्टेड है
नहीं आप देखिए इस वक्त तो हम एप्रिसिएशन ऑफ एविडेंस नहीं करेंगे
यस नॉन
सिर्फ एक चीज बियर विथ मी फॉर 2 minutes हैव सम पेशेंस
आपको बियर नहीं करेंगे तो किसको
हाँ,
करेंगे
इसीलिए
कोर्ट
जो
में
ट्रायल कोर्ट का फाइंडिंग है
हाँ।
आप खाली उसको फ्रॉम द डिस्कशंस मेड अबाउट इंटरनल पेज 14 इशू नंबर 4 के जस्ट ऊपर वाला पैराग्राफ पढ़िए
पैराग्राफ 6 जो है
पैरा नंबर तो इसमें नहीं है लेकिन इशू
From
नंबर
the
4 के
discussion
जस्ट
made above,
हाँ यस
it is clear that this suit has been filed on 12/4/78 when the alleged adoption has been executed on
8576
the by observing all the religious rites including the act of taking and giving at Muda 36 on 5/5/76 by late Gulab Rao with the consent of his wife Fulo Rotain who executed the deed of adoption in favor of Suchkant Manji and the deed was also joined by Baleshwar Manji and his wife Sumati Manji. तो एक बात तो क्लियर
ये
है
पूरा का पूरा ये जो फाइंडिंग है दिस इज पिक्ड अप फ्रॉम द रजिस्टर्ड डीड में जो लिखा है वो यही लिखा है
जी
ठीक है
जी आप पढ़ लिए उसको डीड को तो
हाँ पढ़ लो
या तो उसमें जो है हाँ ठीक
ठीक
है
है।
एडॉप्शन डीड नंबर so
आगे
is
सो
a
द
valid,
एडॉप्शन डीड
genuine and legal document and this adoption deed exhibit B stands fully well
फुल्ली
fortified
फोर्टिफाइड बाय द लॉ
by the law and it is an unimpeachable document and there has not been any velocity. क्या लिखा हुआ है? थोड़ा सा
Any violation of section 5 to 11 of the
11 of the Hindu
Adoption and Maintenance
Act. Therefore, this issue is decided against the plaintiff.
So ultimately ट्रायल कोर्ट ने क्या किया? ट्रायल कोर्ट ने क्या किया? ट्रायल कोर्ट ने बोला 5 to 11 का कोई वायलेशन नहीं है. This is a registered deed. It is an unimpeachable document and applicable.
लेकिन एविडेंस तो ही कंसीडर किया है.
ये फाइंडिंग में आप सब कुछ कंसिडर किया है, लेकिन ये फाइंडिंग में देखिए कैसा.
इसमें एक चीज देखा
It speaks volumes about the mind of the judge.
डिफेंडेंट का जो एडमिशन है उसको भी जरा सा देख लिया जाए. पेज 13 में है.
और आप हमको इतना बताइए, इसके साथ आप जरा फाइंडिंग पढ़िए एपेलेट को.
हम 2-3 चीज पढ़ाएंगे, ज्यादा हुई का समय नहीं लेंगे. 2-3 चीज पढ़ा इसी में केवल जजमेंट पे पेज 13 में जरा सा हुई को दिखा रहे हैं. ये पैराग्राफ जो बिगिन होता है दूसरा के बाद तीसरा. On the contrary, the defendant's learned counsel submitted that the defendant's claim of intercaste adoption has got legal sanction at that is not against the Hindu Adoption and Maintenance Act. It was further submitted on behalf of the defendant that the main plank of the argument of the plaintiff is that no giving taking of the defendant number 3 by Gulab Rao with the consent of Fulo Rotan had taken place. This is their main contention.
उनका मेन कंटेंशन तो ऊपर ही लिखा हुआ है ना.
एक बात और
That is not the main contention.
अटैक तो ही डीड ऑफ एडॉप्शन को ही नहीं कर रहे हैं.
Deed of adoption को fraudulent कोई का
fraudulent
attack
and
करते हैं.
misrepresentation.
नहीं, और इनका कहना ये है कि ये एडॉप्शन हुआ ही नहीं.
नहीं, उनका कहना है.
हाँ, प्लेंटिफ का कहना है.
उनका कहना है. तो एक चीज तो एडमिटेड है कि डीड रजिस्टर्ड हो गया है.
हाँ, deed.
अब जस्ट हमको लेट मी क्लियर. डीड को एक्सेप्ट कर लिए कि डीड तो रजिस्टर्ड हुआ. अब दिस में मिसरिप्रेजेंटेशन और फ्रॉड, तो मिसरिप्रेजेंटेशन और फ्रॉड जो कह रहे हैं उन्हीं को प्रूव करें. क्या फ्रॉड हुआ, क्या मिसरिप्रेजेंटेशन हुआ, दो चीज हम उनको केवल दिखा रहे हैं. एक निकालिए ना, उनकी कब यहाँ पर हाँ लिख रहे हैं. प्लेंट से हम प्लेंट पर पढ़ रहे हैं. बड़ा इंटरेस्टिंग एक चीज है कि इसमें दो आदमी वाइफ एंड हस्बैंड दोनों तरफ का प्लेंटिफ एंड डिपेंडेंट वाइफ एंड हस्बैंड गुलाब राव और उसकी फूलो रोताइन दोनों डीड पर दस्तखत कर रही है. यदि वो जमीन के लिए जो मेरे मित्र ने सबमिट किया, यदि वो जमीन के लिए कोई चीज देना, वो वहां भूगतबंधा होता है और भूगतबंधा जो डीड होता है जिसको हम लोग कहते हैं कि भूगतबंधा डीड हुआ, वो 6 वर्ष के लिए होता है. तो उसके लिए केवल एक ही आदमी आएगा, लेकिन दोनों पक्ष का वाइफ और हस्बैंड आया है. किस पर्पस के लिए आया ये तो एक्सप्लेन नहीं हुआ. लेकिन यहाँ देख लीजिए पैराग्राफ पेज 8 का प्लेंट पे हम पढ़ रहे हैं. The plaintiffs are illiterate, unsophisticated persons, and in case of adoption, they would have consulted their. ये अपने ऊपर ओनर्स ले रहे हैं, कैसे क्या किए नहीं होने से बिल्कुल की adoption, and would not have left things at the mercy of defendant number 1. The defendant number 1, however, bluffed them on the false plea of entrustment. And क्या entrustment है, एकदम बिल्कुल कंप्लीट है. यहाँ हो रहा है कि डीड हो रहा है एक्सक्यूट, उसको हम थोड़ा सा दिखा देंगे. Impressed to them that law regarding manner of entrustment has changed and new procedure have to be adopted executing a registered deed. ये वो रजिस्टर नहीं होता है, भूगतबंधा जो होता है वो एसडीओ के कोर्ट में होता है, 6 वर्ष के लिए होता है. Moreover, taking undue advantage of the addiction, ये important है, addiction of plaintiff number 1 to drinking. The defendant number was keeping in the plaintiff number 1 always in drunken state. हमें पिला के रखता था. अब हम एविडेंस को थोड़ा सा पढ़ देंगे केवल फुल और होता है एंड स्टेट एंड डिड सो इवन ऑन 5/5/1976 मैं जिस दिन था तो उनको पूरा दारू पिला के लाया था। तो ये प्लीड कर रहे हैं, उनका स्पेसिफिक प्लीडिंग है, ये मिस रिप्रेजेंटेशन और फ्रॉड के लिए हो रहा है कि ड्रंकन स्टेट में था तो पति के साथ पति पत्नी दोनों ये सूट फाइल किया है, गुलाब राव का फुलोर होता है, और ये एलेज कर रहा है कि हम बिल्कुल पी करके आए थे, हमको पिला के रखा। अब जरा सा 2 मिनट समय लेंगे क्योंकि इसको देख रहे हैं जो लॉर्डशिप इज टेकिंग ट्रबल टू लुक इनटू दिस। किसका है ये? फुलोर होता है।
अब तक पैरा 7 पढ़ा ना?
पैराग्राफ 17 हम पढ़ रहे हैं।
अभी पैरा 7 प्लेंट का पढ़ा था।
इनका प्लेंटिफ का
हाँ, प्लेंट का पैरा 7 पढ़ा था ना?
जी पैराग्राफ 7 पढ़
पैरा 7 ही पढ़े थे ना अभी आप?
नहीं
प्लेंट का कौन सा पैराग्राफ पढ़े?
प्लेंट का पेज नंबर 8 में पैराग्राफ 9 ना क्या है? आई है कि जी है पैराग्राफ जी है 15 जी
पेज नंबर?
पेज नंबर 8 हमारा सर्टिफाइड कॉपी का जी क्या कहता है कि बिल्कुल पिला करके लाए हमको, क्योंकि प्लेंटिफ दोनों हैं। अब इन्हीं पत्नी का हुजूर जो उनकी थी काय कि उस दिन तो इसमें गुलाब एग्जामिन नहीं हुआ है। हाँ भाई तो कहते हैं गुलाब जिंदा है। गुलाब हैज नॉट बीन एग्जामिन बिकॉज़ ही वाज डेड ऑन दैट डे। जैसा हम पर हमको खत्म कर दीजिए ना, तब आपको हमको खाली आप ही को असिस्ट कर रहे थे। कोर्ट इतना हम लोग को समझ देती हैं, वी आर ऑब्लाइज्ड। अब इतना देख रही हैं, देखिए कोर्ट कचहरी आने पर हुजूर हम पढ़ रहे हैं, हम इसका डिपोजिशन पढ़ रहे हैं केवल फुलोर होता है
सर हम
थोड़ा सा दिखा रहे हैं।
नहीं हम देख रहे हैं।
एलेज कर रहा है, वो कह रहा है स्पेसिफिकली कि ड्रंकन स्टेट में उसको डिफेंडर नंबर 1 रखता था, वो बिल्कुल शराब के इन्फ्लुएंस में थे। He was under the influence of intoxication, deep intoxication. इसलिए उस स्टेट में यही फ्रॉड एंड रिप्रेजेंटेशन का वो एक सपोर्ट ले रहे हैं। अपने ही गवाही में क्या कर रहे हैं पढ़िए, पैराग्राफ 17 हम पढ़ रहे हैं। पैराग्राफ 17
हाँ पढ़िए।
देखा जाए आपको मिलान करके हम पढ़ेंगे तो आप भी दिखेगा।
पैरा 17
और भी ये फुलोर होता है, BW1 फुलोर होता है। उसी के पहले
कोर्ट कचहरी, ठीक है पढ़िए।
ऊपर से ही पढ़ा जाता है। पैराग्राफ 15 का लास्ट हम पढ़ रहे हैं। मेरे पति ने जिम्मानामा के लिए कोर्ट आए थे। जिम्मानामा के लिए एकदम उसी पेज में पैराग्राफ 15 का लास्ट।
हम दोनों पति पत्नी
जिम्मानामा के लिए कोर्ट, हम दोनों पति पत्नी जिम्मानामा के लिए कोर्ट आए थे। उस दिन मेरे पति ने मेरी जानकारी में शराब नहीं किया था। इस चीज को डील किया है ट्रायल को, एप्लेट को। फिर बालेश्वर मांझी का भी घर हमारे ही गांव में है। जिम्मानामा होने से पहले बालेश्वर मांझी ने हम लोगों को कोई झगड़ा नहीं हुआ, हम लोगों से में पहले अच्छा से बातचीत होती थी और अच्छा व्यवहार था। बालेश्वर मांझी ने कितने साल के लिए खेत रोकने दिया मुझे याद नहीं है। कोर्ट कचहरी आने पर मुझे वकील ने जिम्मा वाला कागज पढ़कर सुनाया था। मैं उस वकील का नाम नहीं बता सकती। जो कागज मैंने वकील से पढ़वाया था, अब इसके लिए मुकदमा के लिए वकील का जरूरत भी नहीं है। जो कागज मैंने वकील से पढ़वाया था वो कागज वहां से कहाँ से उठवाया था मुझे याद नहीं। उस कागज की नकल उठाया या नहीं मुझे याद नहीं है। वकालत खाना में वकील ने कहा कि बालेश्वर का पुत्र लिखा दिया है। उसी दिन उसको नॉलेज हो रहा है। बालेश्वर ने मांझी ने वो पुत्र लिखा दिया है। वह लड़का अभी कितने साल का है नहीं कर सकती, स्किप करके पैराग्राफ 18 में आया जाए। मुझे याद नहीं है कि पुष्पपुत्र लेने से कितने साल पहले हमने और हमारे पति गुलाब ने पुष्पपुत्र लेने के बारे में सोचा था। बहुत इंपॉर्टेंट है, इसको ट्रायल कोर्ट और एपलेट कोर्ट दोनों ने उल्लेख किया है। मुझे याद नहीं है कि पुष्पपुत्र लेने से कितने साल पहले हमने और हमारे पति गुलाब ने पुष्पपुत्र लेने के बारे में सोचा था। हमारे परिवार में पति के जीवन काल में इस पुष्पपुत्र को छोड़कर, पति के जीवन काल में, बहुत इंपॉर्टेंट है क्योंकि इसके बाद पति मर जाता है कुछ दिन के बाद, छोड़कर वही उत्सव संस्कार नहीं हुआ था। हमारे भाई गोतिया ने यह पुष्पपुत्र इसलिए दिलवाया क्योंकि मुझे जगह जमीन है, एडमिट कर रहा है हुजूर। ये व्हाट इज रिक्वायर्ड टू बी प्रूव्ड नाउ। ये मिसरिप्रेजेंटेड फॉर पर उनका आंसर आ गया इसी फुलिया रोहतांग के कि उस दिन
अब
शराब
आप
नहीं
हमको
किया।
इस एविडेंस का डिस्कशन एपलेट कोर्ट पे जजमेंट।
मेरा कहना है हम पढ़ेंगे, लेकिन इवन इफ इट इज नॉट बट इट हैज
ऐसा
कंफर्म्ड द
नहीं है,
जजमेंट
सर।
ऑफ द ट्रायल कोर्ट।
ऐसा
देखिए निकालिए तो ट्रायल कोर्ट जैसे
आप
ठीक है।
ट्रायल कोर्ट का के जजमेंट में आप जरा एपलेट कोर्ट का
हाँ, देख
जजमेंट
देख
एक भी ओरल
हुजूर
एविडेंस
का
का
आदेश
कोई
नहीं है।
जिक्र नहीं है। एपलेट कोर्ट पढ़ी।
जी जी एपलेट कोर्ट के जजमेंट जैसा पढ़ी तो हम पढ़ी। माय फ्रेंड पढ़ी।
स्टार्ट से पढ़े।
देखिए एक एक पैराग्राफ पलटते हैं।
जो जो करते
पहला
हैं।
पैराग्राफ है कि किस ऑर्डर के अगेंस्ट में आए हैं। दूसरा क्या केस है, ठीक है। तीसरा है प्रतिवादी का क्या केस है, पैरा नंबर 3 पूरा जिनोलॉजी दिया हुआ है, राइट। उसके बाद चौथा है ये कि बयान वगैरह हुआ है, ठीक है।
इशू पांचवा
हाँ।
इशू
पांचवा में इशू फ्रेम है जो ट्रायल कोर्ट, ठीक है। हो गया यहाँ तक।
7 से पढ़ते हैं।
नहीं एक सेकेंड,
7 से पढ़ते हैं।
नहीं 6 में लिखित बहस दिया क्या दोनों ने दिया।
पक्षों के अभियुक्ता के तर्कों सुना, पत्रावली का अवलोकन किया, उभय पक्ष के अभियुक्ता विरुद्ध चलित बहस भी प्रस्तुत की गई और जो पत्रावली पर है
पैरा 7 इज
अपील करता
अपीलकर्ता का आर्गुमेंट,
हाँ।
मुख्य तर्क ये है।
है। मुख्य तर्क ये है कि दस्तावेजनामा सुल्तान गुलाब राउत बिल्कुल जारी है तथा वादीगण के साथ कपट मिथ्या कथन करके प्रतिवादी में हासिल किया, जबकि प्रतिवादी उत्तरदाता के विज्ञान अधिवक्ता इस दस्तावेजनामा बिल्कुल सही होना कहते हैं। अपीलकर्ता के
ये आर्गुमेंट है अपीलेंट का,
हाँ?
आर्गुमेंट है ना अपीलेंट का जो रिकॉर्ड।
हाँ, दोनों का है, जो इस दोनों का चर्चा कर रहे हैं।
ठीक है।
जबकि प्रति उत्तरदाता के विद्यमान वस्तु इस दस्तावेज को घोषणाओं को बिल्कुल सही होना कहते हैं। अपीलकर्ता के विद्वान अधिवक्ता अपने बहस के इस 10 में वाक बिंदु संख्या 3, 4 और 8 को मुख्य बिंदु होना कहते हैं तथा कहते हैं कि इनका निर्धारण अधीनस्थ न्यायालय द्वारा सही ढंग से नहीं किया गया। वाद संख्या बिंदु संख्या 3 इस असर का है कि क्या सुल्तान गुलाब राउत और पुरोहित का वैध दत्तक पुत्र है। वाद बिंदु संख्या 4 इस असर का है कि क्या गुलाब राउत पुरोहित के साथ बालेश्वर ने कपट मिथ्या करके दस्तावेज संख्या 94-76 लिखवाया था। वाद संख्या 8 इस असर का है कि क्या दस्तावेज नामों 94-576 विधि मान्य सम्मिलित दस्तावेज है। तीनों बिंदुओं का अर्थ एक ही है कि अधीनस्थ न्यायालय ने तीनों बिंदुओं पर निर्धारण अपने निर्णय के पृष्ठ संख्या 10, 11, 12, 13 में हम 14 में किया है। अपीलकर्ता के विद्वान अधिवक्ता महोदय तर्क देते हैं कि वादी गुलाब राउत बुरी संगत में पड़ गया था। वर्ष 1976 में शुरू में उसके हल जोतने वाले मवेशी मर गए थे। इस परिस्थिति का फायदा उठाकर बालेश्वर मांझी उससे मोजा पिछली डुआ उमडुआ की जमीन जोतने के लिए अस्थायी तौर पर लिया था। 4-5-76 को बालेश्वर मांझी तथा उसकी पत्नी गुलाब राउत को देवघर न्यायालय में ले आया और उस जमीन के सुपुत्रनामा का कागज बनवाने के बाद बताकर कपट करके दस्तावेज गोदनामा अपने लड़के सूर्यकांत मांझी के पक्ष में करा लिया, जिसकी जानकारी गुलाब राउत को 10 फरवरी 1978 में हुई। उसने ये बात पत्र प्रस्तुत किया है। वादी की पक्ष की ओर से जो साक्षीगण प्रस्तुत हुई उनमें से कोई ये नहीं बताता है कि वादी के जोत वाले मवेशी भैंस के बच्चे पाड़ा में थे या बैल थे, ऊँट थे या गधे थे या घोड़े थे, और कोई साक्षी ये नहीं बताता कि जोत वाले मवेशी को कौन सी बीमारी के दौरान उसके दवा किस डॉक्टर ने कराई गई थी। मरने के बाद मवेशी को कौन हटाया, उससे कोई न्यायालय के समक्ष कुछ नहीं किया है। जिस कारण वादी कम अपील करते या तथ्य साबित कर न्यायपूर्ण और सफल हो गए कि बस उनसे उसके दूध वाले मवेशी मर गए। वादी कम अपील करता कि उसे दूसरा तथ्य दिया गया है कि वह अपील करता है कि दूधने वाला मवेशी मर जाने के बाद बारिशों जो उसके यहाँ पहुंचा था उसका जमीन दूधने होने के लिए इस बिंदु पर भी कोई स्वतंत्र साक्षी अपील करता कम वादी
इससे तो
नहीं किया गया।
जस्ट अ मोमेंट, यहाँ तक के डिस्कशन से एडॉप्शन डीड के बारे में कोई
अभी तक
नहीं है ना, आगे
सवाल पुस्तक ये स्वीकार करता है कि उसने उसके सामने बालेश्वर माजी ने गुलाब से ऐसे कोई बात दाता कम प्रतिवादी वर्ग की ओर से दस्तावेज गोतनामा 5 वर्ष के वास्ते गुलाब बालेश्वर माजी को न्यायालय प्रस्तुत किया गया था, जिस पर गुलाब राव का अंगूठा निशान मौजूद है। इस दस्तावेज पर सुल्तान मांझी के पिता बालेश्वर मांझी का हस्ताक्षर है और उसकी माँ सुमति का अंगूठा निशान मौजूद है। तो साक्षी श्री जगनारायण का पांडे का भी हस्ताक्षर है। इस दस्तावेज गोदामा पर मौजूद है। हिंदू एडॉप्शन एक्ट के अनुसार जब कोई रजिस्ट्री शुदा दस्तावेज गोदामा न्यायालय के समक्ष प्रस्तुत किया जाएगा तो न्यायालय उसके बारे में अवधारित करेगा कि हिंदू एडॉप्शन एक्ट के प्रावधान के अनुसार सही लिखा गया है ताकि इसके साथ साबित न किया जाए। इस प्रकार वादीगण अपीलकर्तागण की जिम्मेदारी थी कि ये साबित करे कि दस्तावेज गोदामा हिंदू एडॉप्शन प्रावधान विपरीत और ऐसा साबित करने के लिए अभियुक्तों ने आधार लिया है कि वादी गुलाब राव की दूधने वाला मवेशी 1976 मर गया था तो बालेश्वर उससे मिला और उसे अस्थायी तौर पर जोतने के लिए लिया और जमीन का सुपुत नामे दस्तावेज दिखाने के लिए गुलाब राव को देवघर कचहरी लाया था उस दस्तावेज गोदनामा पे बनवा लिया। दस्तावेज गोदनामा पर गुलाब राव और उसकी पत्नी दोनों ने हस्ताक्षर किया और विलिखित किया है कि वे सुल्तान मांझी को गोद ले रहे हैं तथा इस दस्तावेज पर बालेश्वर मांझी और उसकी पत्नी सुमिति ने हस्ताक्षर किया है तथा विलिखित किया है कि वे अपने नाबालिग पुत्र सूर्यकांत मांझी को गुलाब राव को बतौर दत्तक पुत्र दे रहे हैं। यदि बालेश्वर मांझी गुलाब राव को कचहरी जमीन का जिम्मा लिखाने लाया था तो फिर गुलाब राव की पत्नी पुरोरताइन और उसके साथ किसी कागज पर हस्ताक्षर या अंगूठा निशान लगाने जाने का कोई प्रश्न नहीं होता। बुक बंधाने को देयर इज नो रिक्वायरमेंट ऑफ वाइफ। दस्तावेज गोदानामा 5-5 के रजिस्ट्री शुदा होने के कारण न्यायालय अवधारित करती है कि ये दस्तावेज को लिखे जाने के समय सब रजिस्ट्रार देवगन ने गुलाब राव तथा उसकी पत्नी पुरोरताइन को बुलाया होगा तथा उनके दस्तावेज गोदनामा के बारे में बताया होगा। इसके बारे में यह दस्तावेज गोदनामा रजिस्टर्ड हुआ होगा जैसा कि दस्तावेज गोदनामा की प्रथम पृष्ठ उस पर अंकित है तथा उसके सब रजिस्ट्रार महोदय देवगन ने हस्ताक्षर बनाए। ऐसी सूरत में
सारा का सारा प्रिजम्पशन पर ही चला गया है ना।
ना
इस यही है फाइंडिंग
और
नहीं और कोई फाइंडिंग नहीं, यही है बस, स्टोरी ओवर। एक भी ओरल एविडेंस का जिक्र है, एक भी ओरल एविडेंस का जिक्र है, नॉट इवन वन ओरल एविडेंस ऑफ बोथ द पार्टीज हैव बीन डिस्कस्ड। यही बोला कि रजिस्ट्रार साहब ने पूछा होगा, बताया होगा, बुलाया होगा, समझाया होगा और इसीलिए ये वैलिड
नहीं, इसलिए इसमें केवल के सामने ये सबमिट करना चाहते हैं। ये इस बैकग्राउंड में है कि डीड रजिस्टर्ड है।
ये अगर डीड रजिस्टर्ड है,
लेट मी एक्सप्लेन।
नो, आई जस्ट वांट टू नो फ्रॉम यू, फर्स्ट एपेलेट कोर्ट को ओरल एंड डॉक्यूमेंट्री एविडेंस को देखना है कि कुछ नहीं देखना है?
कनकर कर रहा है तो बहुत नेसेसरी नहीं है, लेकिन डिफर कर रहा है तो नेसेसरली उसको कंपल्सरी है कि देखना ही है। कनकर रहा है तो इन माय हम्बल सबमिशन देयर ऑथोरिटीज आल्सो ही इज नॉट रिक्वायर्ड टू गो इन डिटेल, लेकिन यदि डिफर करेगा तो इन डिटेल ही जाना पड़ेगा एंड ही फॉर फॉर्मिंग द अदर ओपिनियन अदरवाइज देन द ट्रायल कोर्ट, तो ही विल हैव टू एक्सप्लेन इट आल्सो व्हाई इज डिफरिंग फ्रॉम दैट। यहाँ पर कनकर कर रहा है इन माय हम्बल सबमिशन, इफ इज कंकरिंग then lords in my humble submission is not required. One thing जो हम दिखाना चाहते हैं, मिसरिप्रेजेंटेशन और फ्रॉड पर केस उनका है, स्पेसिफिक है। यहाँ पर मेरा जो अभी तक हुजूर के सामने नहीं, जो Watson has taken pain to go in detail in प्लेंट में जो कह रहे हैं कि शराब के इन्फ्लुएंस में उस दिन नहीं आए थे, बराबर पिला के रखते थे, लेकिन इनका एविडेंस में है फ्लोर होता है none other than the wife was prosecuting the case as plaintiff on behalf of her husband also. वो कहीं पर भी नहीं बोली कि अंडर द इन्फ्लुएंस ऑफ लिकर, तो जो प्लीडिंग था उसका कॉन्ट्ररी एविडेंस था।
सर
तो
इसका डिस्कशन कहाँ है?
इस चीज को
PW1 का एविडेंस का डिस्कशन कहाँ है?
ट्रायल कोर्ट किया है,
ट्रायल कोर्ट डिस्कस किया।
ट्रायल कोर्ट किया है, निकालिए ट्रायल कोर्ट को देखिए, डिस्कशन किया है, दिस इज द बेसिस ऑफ है कि यहाँ रहे जो पेश तेरा में एडमिट किया है, जो फर्दर
नहीं आप उसका डिस्कशन दिखाइए।
plaintiff Fulo Rotan in her evidence at paragraph 18 has admitted the adoption, and PW2 Vidyanath Rao in paragraph 4 has also admitted about the adoption, and paragraph 6 of his evidence Vidya Rao has admitted that he had not, इसलिए वो तो डिस्कशन है।
आप जरा देखिए यहाँ पर अकॉर्डिंग टू लॉयर फ्रॉम द प्लेंटिफ, उसके बाद अकॉर्डिंग टू
पेश तेरा
लॉयर
में, पेश तेरा में,
ठीक है।
According to learned counsel, middle paragraph हम पढ़ रहे हैं, learned counsel of the defendant, there is overwhelming evidence on the point of giving and taking adduced by the, इसमें फोटोग्राफ वगैरह भी है, उस दिन जो एडॉप्शन हुआ उसको फोटोग्राफ निगेटिव पॉजिटिव वो भी एग्जिबिट हुआ है उसको by the defendant.
The trial court has come to a finding that this particular document is an unimputable document, right? But the court has proceeded on the assumption that it is full and final. And the learned appellate court has not discussed any of the material evidences. Any material, no evidence has been discussed except the deed itself.
I have submitted for Lordship that if the trial court, from the finding recorded by the trial court, if the appellate court would have deferred not in that situation.
आप बताइए ना कि कहाँ लिखा है ट्रायल कोर्ट में कि that the handing over, taking over, etc. has been proved, ऐसा कहाँ लिखा है? दोनों का सबमिशन लिखा है, प्लेंटिफ का सबमिशन, डिफेंडेंट का सबमिशन।
एविडेंस को लेके बोल रहा है, एविडेंस को
नहीं इसको प्लेंटिफ ने भी तो एविडेंस को लेके बोला है। अब देखिए, you just have a look at it. According to the learned lawyer of the plaintiff, amongst the 9 witnesses, PW1, who has clearly denied the adoption ceremony of any kind at her residence. First appellate court has not done the needful.
Para 813 में three witnesses of PWs have admitted that adoption. Even the PW1
बोल रहा है, वो बिल करेगा।
कहाँ है finding? Show me the finding.
पढ़ देते हैं।
Show me the finding.
Page 13.
हाँ पढ़ी।
It was further argued on behalf of
आर्ग्यूमेंट है ना, आर्ग्यूमेंट बात पढ़िए, फाइंडिंग पढ़िए।
हम उसी में लिखते हैं, उसमें इसको डिस्कस करते हुए ना फाइंडिंग दिया गया
ऐसा
है।
नहीं है,
इसको पैरा 18 को देखा गया।
फाइंडिंग एक सेकंड, सबमिशन दोनों काउंसिल वेरियस एविडेंसेस को रेफर करेंगे, बताएंगे इसने ये बोला, वो कुछ कॉन्ट्ररी बोलेगा, ये बोले, लेकिन फाइंडिंग कहाँ है ट्रायल कोर्ट का भी? कि because of this particular evidence it is proved that this ceremony had taken place.
From the discussion made above, it is clear that suit has been filed or itna when the alleged adoption ritual has been executed during all the religious rites, including the act of taking and giving at Moja 36 on 5 March. So सारा evidences.
This is mentioned in the deed itself. It is referring to the deed itself.
एविडेंस में भी तो आया है जो 36 में हुआ, हम पढ़ देते हैं, बाकी एविडेंसेस को भी हम लोग पढ़ देते हैं. मेरा 6 डिफरेंट नंबर 6, 7, 8.
The last time I am putting you a question, has the appellate court considered any of the oral evidences?
वो उस तरह से स्पेसिफिक डिस्कशन नहीं है. जो नहीं है तो उसको कंसीडर करेंगे, लेकिन मेरा सबमिशन होगा कि इट इज कंकरिंग. I should not repeat it. I am repeating it. Saying sorry. If it would have differed from the judgment of the learned trial court, it was not incumbent upon him to discuss the evidences, every piece of evidence. In this case, he is concurring with the judgment of the trial court. Therefore, he was not required to discuss it.
You see, before this discussion in half paragraph, which has been made by the learned trial court, show me any finding of the learned trial court that on the basis of oral evidences he comes to a finding that this ceremony had taken place. Show me one finding of the learned trial court.
Just आर्गुमेंट जो है जो किए हैं, और आर्गुमेंट में जो विटनेस का जो डिपोजिशन है उस पर कमेंट किए हैं. हुजूर ने जो प्रश्न किया है वो हम समझते हैं, उसमें स्पेसिफिक इतना ये विटनेस है, ये कहा है.
एक भी किसी भी जजमेंट का बेसिक 3 पार्ट्स है. Argument of the appellant, argument of the respondent, and the finding of the court. ये जो दोनों का आर्गुमेंट लिखा कर और सीधे जो आप कोई भी कोर्ट अगर कंक्लूजन पे पहुंच जाए,
ऑर्डर रेफर कर रहा है,
रेफर कर रहे हैं, बट
लेकिन उसको अपने से डिस्कशन नहीं किया,
नहीं है ना डिस्कशन कि भाई एक प्लेंटिफ ने ये बोला, डिफेंडेंट ने ये बोला, एंड दिस इज माय फाइंडिंग. कहीं तो कुछ ऐसा फाइंडिंग आना चाहिए ना कोर्ट का. दोनों का आर्गुमेंट लिखा कर आप एक पैराग्राफ में एक अपना फाइंडिंग दे दीजिए.
आर्गुमेंट में कमेंट किए हैं, आर्गुमेंट में कमेंट किए हैं. ये जो एविडेंस जैसे हम पढ़ रहे हैं, कुछ पेज 10 का थोड़ा पेज 10 का ऊपर से पढ़ रहे हैं. पेज 10 का जो पैराग्राफ स्टार्ट होता है, डिफेंडेंट्स हैव आल्सो entered oral evidence and
16 witnesses examined altogether 16
witnesses. पेज 10 का जो शुरुआत है, अब हमारे में तो हाथ का लिखा हुआ है, the documentary evidence adduced on behalf of the plaintiff is the certified copy of the voter list of Jamtara Assembly Constituency 155 of the year 1995, which is exhibit 1. Defendant have also entered into oral evidence and have altogether examined 16 witnesses in support of their case. DW1 Ganesh Prasad Shah, DW2 Gauri Shankar Barmula, Mali Rani, DW5 Purnanand Thakur, DW9 Basdev Mahbub, DW10 Vinod Kumar, Malviya, DW11 Ugan Mahbub, DW13 Punit Dev, DW12 Baleshwar Das, DW5 15 Chandra Shekhar Gupta, DW6 Dineshwar Manji, 7 Kuleshwar Yadav, DW8 Dev Narayan Yadav, DW12 Vitlal Mahato, DW16 Baleshwar Manji are the material witness. Besides oral evidence, defendants have also adduced documentary evidence in support of their case. Exhibit A is the signature and certificate of the deed writer, Purnanand Thakur, on the adoption deed. Exhibit A/1 to A/5 is the signature of writing of the stamp vendor, late Tejnarayan Dubey. On the adoption deed, Exhibit B is the original adoption deed, number 98 of so and so. Exhibit C to are rent received issued by Government of Bihar. Exhibit D is the negative of photographs and Exhibit D1 is the positive of the photographs. ये adoption deed का है. Exhibit E is the envelope of the negative on which name, number and date written. Exhibit F is the extract copy of electoral roll of Jharkhand Assembly Constituency 159 of so and so. Exhibit G is the residential certificate of Devnarayan Ram Devkantra, and Exhibit H is the copy of caste certificate of Devkantra. The stamp of the fine photo studio on back of photograph is so and so. Therefore, documentary evidences plots have been referred to in order to appreciate the evidence of the parties and for the just decision of the case. For all, I want to like to take the issue number 8 for discussion. Issue number 8, there is a specific pleading in the plaint and definite case of the plaintiff is that the present suit was originally filed by the plaintiff Gulab and his Raut and his wife Furotai. But during the pendency of the suit, the farmer died and so letter alone continued to the suit and suit was filed for declaration that the defendant number 3 was never adopted by the plaintiff and so the adoption deed number so and so not backed by act of adoption. An act of giving and taking is adoption is invalid and should be cancelled. The plaintiff also prayed for declaration of their title and recovery of possession of their daily land given in the schedule. According to the learned counsel of the plaintiff, the main dispute is regarding adoption. In the plaint, there is emphatic denial about adoption of the defendant number 3 by Gulo Ramraju and Furoro on so and so. Or any other day, it is asserted that there was never any ceremony as alleged. The adoption deed, which is an invalid document, maneuvered on the false plea of entrustment of land of cultivation. It has further been submitted on behalf of the plaintiff and plaintiff had no natural issue and having grown old, they had no hope of begetting any child. Under such circumstances, any adoption by them is naturally expected to be well proclaimed in the locality according among castemen, friends, relations, family, priests, barbers, others, as the prevalent in the community. The plaintiff had their residence in village Ichi, Oria, and also Mohalla Chhatisi of the rural town. Chhatisi is the predominantly inhabitant of Dhanu caste to which the plaintiff belonged, and there are 36 houses of the said caste. They are apart from that they have their relations in the village Pichi. They have their Rohini in Pichi and also Rohini. All the plaintiff have inherited properties from paternal and maternal side. So the family priests of both sides are attached to the plaintiff. It has further been argued, or it has been certainly arguments have been mentioned. But with the discussion of their evidences,
There is mention that this evidence was produced by both the sides. There is mention that this particular counsel argued this, the other side argued this, they referred to this, they referred to this, but there is no finding of the court.
आर्गुमेंट में ही उनके जो कंटेंशन में ही
दोनों का कॉन्ट्ररी
जो आप कर रही है हम उसको देख रहे हैं,
सीनियर है सर,
जो है वो उसके बियॉन्ड
ये बहुत ज्यादा मुश्किल, और ये सिर्फ एकमात्र केस नहीं है ऐसा. दिस इज क्रिएटिंग लॉट ऑफ प्रॉब्लम्स.
अब देख लीजिए एक बात, अब छोड़ दीजिए, हम हुजूर के सामने जो बहस कर रहे हैं थोड़ा देर हट जाइए. ये बेचारा सब्जेक्ट कितना स्टैंड लिया हाथ से लिखने में, उसको सारा हाथ से ही लिखना पड़ा होगा उस समय में, जबकि किसी को स्टैंड नहीं.
आप अपने समय को याद करिए जब आपके सीनियर 50-50 पेज डिक्टेशन देते थे और आप बैठ के चेंबर में लिखते थे. हम लोग भी लिखे हैं. आजकल किसी जूनियर को बोल तो दीजिए.
अरे लेवे नहीं करेगा.
तो इसीलिए वो जमाने की
लेकिन
बात आप
ये
छोड़
एक चीज
दीजिए.
है, these are the things. लेकिन एक जो छोटा सा बात हुजूर के सामने एम्फेसिस देंगे, इनका फ्रॉड एंड मिसरिप्रेजेंटेशन किसी भी एंगल से प्रूव नहीं होता है.
PW1 का एविडेंस बहुत स्ट्रांग है. There cannot be any doubt. लेकिन सेकेंड अपील में हम एक पर्टिकुलर एविडेंस को कंसीडर करके हम कैसे कोई फाइंडिंग रिकॉर्ड करें?
दोनों हुजूर तो देख रहे हैं.
आप डेट फिक्स कर देते हैं, हम लोग जाके बहस कर लीजिए, 1 महीना में डिस्पोजल.
हुजूर तो दोनों देख रही हैं कि दोनों कोर्ट ने कंकर किया है.
कंकर ट्रायल कोर्ट ने भी नहीं डिस्कस किया है. देयर इज नो फाइंडिंग रिकॉर्डेड, और एपेलेट कोर्ट ने तो कुछ भी नहीं किया. आई डोंट हैव एनी ऑप्शन बट टू रिमांड. I don't have any option. डेट बताइए ना, कौन सा डेट?
नहीं, हम समझ गए. आप बार-बार बोलिएगा और हम नहीं समझेंगे. हम तो एक बार में समझ गए.
किस दिन आप लोग अपीयर होइएगा कोर्ट में, ये बता दीजिए. यहीं से डेट फिक्स करते हैं हम लोग, वहाँ थोड़ी करते हैं.
कब अपीयर होइएगा सब बोलिए ना.
अपीलेट कोर्ट में बताइए कब अपीयर होइएगा. हम 3 नवंबर कुछ केसेस में डेट फिक्स किए हैं अपीयरेंस.
आप बोलिए ना, हम तो कौन ले जाएगा. हम लोग को देता है पैसा,
हम दोनों में से कोई तो आज जाएगा
नहीं. जाइएगा ना तो बस इस केस को और 10-20 साल एडजस्ट.
नहीं एक तो
एक डेट फिक्स कर दिया.
लंबा नहीं
डेट
कीजिए.
फिक्स लंबा होगा तो
Within
काम
3
करिए.
weeks.
डेट होगा फिक्स.
Within 3 months
My friend
from the receipt of the.
एक्चुअली हुजूर एक बात हम
ऐसा नहीं करना है. हम यहाँ से डेट फिक्स करेंगे आपको किस दिन अपीयर होना है, और उसके बाद जो है
कोर्ट अपना
हियरिंग करके आप कर.
कोई
और अगर आप नहीं अपील करेगा तो डीएफडी हो जाएगा. आप ही अपीलांट है ना,
ठीक है. हम तकबीर होंगे
कर देंगे डीएफडी हम लोग. फिर रेस्टोर कराते रहिए.
ये संथाल डेंसिया का केस हम और हमारे फ्रेंड दोनों
सर, जब आप लोग यहाँ से पटना से आए हैं और सीनियर यहाँ एंगेज है, तो हम ऐसा तो नहीं मानेंगे. नहीं, ये बिना इंस्ट्रक्शन के अपीयर नहीं
हम लोग
होते.
का इतना दरभंगा हाउस में मेरे
एक ही रूम में हम लोग दोनों बैठते थे.
दरभंगा हाउस में मेरे मित्र बैठते हैं. एक बार मुलाकात होनी थी, लेकिन डेस्टिनी हैज सेपरेटेड मी.
तो इसीलिए
हुजूर ये संथावरा डेंसिया में हमारे फ्रेंड इस केस की बात हम नहीं कर रहे हैं, हमारा इनका दोनों का कॉमन एक्सपीरियंस है, लैंड ग्रैब करने का एक ही तरीका है एडॉप्शन।
चलिए वो एडॉप्शन भी चलता है वहाँ।
कि ना वहाँ कोई सेल है, ना मोर्गेज है, ना एडवांस पैसा है, पटना है कि ना बिल्कुल ने डिसाइड कर दिया।
अरे आप केस अभी 3 दिन पहले बहस किए हैं, संथाल जो है अडॉप्ट कर लिया दिक्कू को।
वही तो कह रहे हैं।
तो सबसे
वो
देख रही
हुजूर
है।
हम कहते हैं,
हम
इसके
लोग
सिवा
का हर
नहीं
मौका
कह
है बहस करने
रहे।
का।
एक भी एडॉप्शन नहीं है। एक हमारे रिलेशन थे, माने दिक्कू ही
लेकिन यहाँ जब रजिस्ट्रेशन हो जाता है तो हाथ से दे जाता है।
रजिस्ट्रेशन का सिचुएशन दूसरा है।
वही है।
रजिस्ट्रेशन फाइनल तो नहीं ना है, लॉ में तो सीधा बात है।
ठीक है ना,
नहीं,
इसीलिए तो
लेकिन
आप
वही तो
लोग यहाँ
टेस्ट
पर
होगा।
हैं।
आखिर वही तो टेस्ट
नहीं,
होगा।
देना और लेना ये सुप्रीम कोर्ट ने कहा कि साइन हुआ नन है, हुजूर हम दिए हुए जजमेंट नोट में।
नहीं तो
That is a must.
जजमेंट तो है कि हुजूर अब जजमेंट छोड़ दीजिए, जब हम लोग कंसीड
हमको
करते हैं
लगता है कि
रिमांडेड तो रिमांड
कर
कर दिया
दिया
जाए।
जाए, कोई डेट फिक्स कर दिया जाए फॉर अपीयरेंस दोनों पार्टी को एग्जैक्टली।
एक जजमेंट काफी होगा।
हम दोनों agree
2002 सुप्रीम
करते हैं,
SC
कोई दिक्कत नहीं।
356।
जो नहीं है तो हम लोग
देवघर में जी इसको गाइड करेंगे हमारे फ्रेंड, उनका कुछ व्यक्तिगत दिक्कत हो गया है इधर
अरविंद चौधरी हैं
अरविंद
इनके
चौधरी।
एडवोकेट होने का।
एडवोकेट ने कहा
लेकिन जो है
एनीवे कोई
एक जो टाइम हो दोनों का अभी दशहरा
ऑर्डर
के बाद,
ऐसे नंबर 261 of 2003।
छठ के बाद
अब क्या
3 नवंबर 3 नवंबर।
सुन ले से 5 नवंबर चूंकि वो है पूर्णिमा वगैरह है, 5 नवंबर के बाद कोई
5 नवंबर के बाद कोई भी डेट, ठीक है। 5
उसी
पूर्णिमा
तरह होगा फिर अगला डेट
10 तारीख 10 नवंबर।
बहुत है, बहुत समय है। अभी तो अक्टूबर भी नहीं है।
सब छुट्टी दुर्गा पूजा है, रक्षाबंधन दिवाली है, ये पूरा छुट्टी।
For the learned counsels appearing on behalf of the parties, this appeal has been filed. Against the judgment dated 20/2003, within bracket decree signed on 3/3/2003, passed by learned additional district judge FTC number 4, Devghar, entitled appeal number 10 of 2000/17 of 2002, affirming the judgment dated 31/1/2000, within bracket decree signed on 8/2/2000, bracket close, passed by learned sub-judge Roman 5 Devghar, entitled suit number 47 of 78. The suit was dismissed by the learned trial court, and the judgment was upheld by the learned first appellate court. Accordingly, the plaintiff is the appellant before this court. This appeal was admitted for final hearing by the order dated 15/7/2004, framing the following substantial question of law, inverted comma: whether the judgment and decree of the lower appellate court is illegal and against the judicial propriety for non-consideration and non-discussion of the evidences on record. The learned counsel for the appellant has submitted that the suit was filed for the following relief. ये इसका डिग्री में मिलेगा ट्रायल कोर्ट डिग्री. The learned counsel for the appellant has submitted that the core issue involved in the case was in connection with legality and validity of adoption of defendant number one, adoption of defendant number one,
Three.
adoption of defendant number 3.
He's son of defendant number 1 and 2.
Natural
who
son.
is the natural son of defendant number 1 and 2. The learned counsel submits that though the deed of adoption was registered, but the specific case of the plaintiff was that it was fraudulently registered. He submits that as per section 16 of the Hindu Adoption and Maintenance Act, there is a presumption in connection with a registered deed of adoption, but such presumption is a rebuttable presumption. The learned counsel has submitted that the suit was highly contested. Both the parties led oral and documentary evidences in support of their respective case. Documentary भी था क्या? Documents भी था क्या?
Stated in
अच्छा ठीक है. Both the parties have used oral and documentary evidences, but the learned trial court, though has referred to the evidences and the case of the respective parties and their arguments, but primarily was swayed away by the fact that the deed of adoption was a registered document and was unimpeachable. The learned counsel has further submitted that so far as the first appellate court is concerned, there is no discussion of oral and documentary evidences by recording the finding and upholding the judgment of the learned trial court. He submits that the learned first appellate court was swayed away by the fact that the deed of registration was that the deed of adoption was a registered document duly signed by the parents, the adoptive parents and also the natural parents of the defendant number 3, and that the registrar must have made the necessary queries and ultimately upheld the judgment of the learned trial court. The learned counsel has relied upon the judgment passed by Honorable Supreme Court, which is reported in 2002 ब्रैकेट में रहेगा 3 SCC 634.
हमको जस्ट सॉरी हमारा जो रूलिंग है कंकरेंट पेंडिंग में इंटरफियर नहीं कर उस पर कुछ डिसीजन है नहीं
आप दे दीजिए. एक सेकंड होल्ड करिए. आपका साइटेशन जरूर सीधा ब्रैकेट 2002 ब्रैकेट क्लोज 3 SCC 634 and has submitted that the law is well settled that Section 16, there is only a presumption with regard to adoption under Section 16 of Hindu Adoption and Maintenance Act, but the same is a rebuttable presumption. And in case any dispute is raised, the same has to be dealt with, considering the oral and documentary evidences based on it. The learned counsel has submitted that the first appellate court, being the final court of fact and law, and the proceeding therein is a continuation of suit, is duty bound to consider the oral and documentary evidences placed on record, and the same would be in accordance with, and the appeal is to be decided in accordance with the provisions of Order 41 Rule 31 of the CPC. The learned counsel submits that even no point of determination as such was framed by the learned. आप लोग सुनिए please. There is no point of determination framed by the learned first appellate court.
No.
Even the first appellate court has not framed any point of determination before deciding the case. The learned counsel has also submitted that the plaintiff had also prayed for a declaration of title with respect to Schedule A property. The same has neither been considered by the learned trial court nor has been considered by the learned first appellate court. He has submitted that no issue to that effect was framed. The learned counsel has submitted that in absence of complete non-consideration and non-discussion of the evidences on record, the first appellate court's judgment cannot be sustained when seen in the light of Order 41 Rule 31 of CPC, and the judgment passed by the learned first appellate court be set aside and the matter be remitted to the first appellate court for fresh consideration in accordance with law on the basis of materials already available on record. Order 41 Rule 11 का कोई citation डाल देंगे? लाए हैं? अभी एक लिखाए हैं सिर्फ. अभी पंकज जी को लिखाए हैं. The learned counsel appearing on
2022 3SSC page 90.
2022
3SSC page 90.
page 90.
2021
2021
10SSC
10 SSC
page 777.
ये दोनों judgments. The learned counsel appearing on behalf of the respondents has vehemently opposed the affair and has submitted that there are concurrent findings recorded by both the courts with regard to legality and validity of adoption, and under the second appellate jurisdiction, there is no scope for any interference. He has also submitted that there is no scope for de-appreciation of evidence at second appellate stage, and therefore the impugned judgment passed by the learned first appellate court upholding the judgment passed by the learned trial court does not call for any interference. He has also submitted that once the learned trial court has referred to the materials on record and come to a finding, under such circumstances, the learned first appellate court need not again refer to the evidences on record and come to a finding, particularly when the learned first appellate court is to uphold the findings of the learned trial. The learned counsel has relied upon the judgment passed, बताइए,
1983 volume 1
1983 volume 1
Supreme Court cases
SCC
Supreme Court cases page 35
34
35
30,
and another judgment is that AIR 1963
1963
Supreme Court
Supreme Court
page number 1633
1633. दोनों का पैराग्राफ बताइए. '83 वाला जजमेंट लीजिए. The learned counsel has relied upon the following judgments. Bracket 1983 1 SCC case 35. ये तो AIR है.
8 and 20 SCC.
नहीं SCC दिया. पहले 8 and 20. SCC का पहले 8 and 20. लीजिए प्लीज.
इसका 63 में बताइए. 10 and 11.
पैरा 10 and 11. AIR 1963 SC 1633 का पैरा ये पैरा 10 एंड 11 को भी कोट कर देंगे और उसका भी पैराग्राफ को भी कर देंगे। दीजिए जरा 81 वाला टेस्ट ये पैरा 8 एंड 20 को भी कोट करेंगे 81 वाले जजमेंट। After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that on the basis of rival claims in connection with the legality and validity of deed of adoption, on the basis of rival claims between the parties, the following issues were framed by the learned tribunal. Quote कर लेना। The learned trial court, while considering the findings, has recorded that plaintiff has adduced both oral and documentary evidences. Altogether, 9 witnesses were examined on behalf of the plaintiff. The details of the witnesses have been mentioned. Amongst the documentary evidences, the plaintiff adduced a certified copy of voter list of Jamtara Assembly constituency of the year 1955. It was marked Exhibit 1. So far as the defendants are concerned, they have examined altogether 16 witnesses in support of their case. And also adduced documentary evidences. Exhibit A was the signature and certificate of the deed writer on the deed of adoption, Exhibit A/1 to A/5 was the signature and writing of the stamped vendor on the adoption deed. Exhibit B was the original deed of adoption, number 98, dated 5/5/1976. Exhibit C was the C to C2 were the rent receipt issued by the government of Bihar. Exhibit D was the negative of the photograph. Exhibit D/1 was the positive of the photograph. Exhibit E was the envelope of the negative on which the name, number and date was written. Exhibit F was the extract copy of the electoral roll of Jharkhand constituency of the year 1995. Exhibit G is the residential certificate of Deoman Rao. He is the adopted son of defendant number 3. And Exhibit H is the copy of the caste certificate of defendant number 3. The stamp of the fine photo studios were marked as Exhibit X/1. Thus, both oral and documentary evidences were reduced. The learned trial court took up issue number 8 as the main issue. This court also finds that the learned trial court has referred to the specific pleadings of the parties, the arguments of the parties, and thereafter the argument of the parties and the argument of the counsel for the plaintiff by referring to the various oral evidences, by referring to the evidences placed on record, and similarly the learned trial court similarly recorded the submissions of the defendants with respect to the various oral and documentary evidences. Also referred to the rulings cited by both the parties and ultimately gave a finding as follows. ये कोट करना है. Running page 34 to 33 है. Internal page 14 of the trial. So far as other issues are concerned, they were decided as under. ये छोटा-छोटा है. This court finds that so far as the learned first appellate court is concerned, the findings has been recorded the first appellate court is concerned, the first paragraph of the judgment deals with the background. Second paragraph deals with the case of the appellant, who was the plaintiff. And third paragraph deals with the case of the defendant. The fourth paragraph deals with the case of defendant number 3, and the fifth paragraph enumerates the issues framed by the learned trial court. The 7 paragraph. In paragraph 6, the learned court records that both the parties had filed their written submissions. In paragraph 7, the learned court records that as per the argument of the appellant, the main issues for consideration was issue number 3, 4 and 8. Thereafter, in paragraph 8, the learned court again considered again recorded the evidence of the recorded the argument of the appellant, and ultimately in paragraph 8 itself, the finding has been recorded by the learned first appellate court, primarily referring to the registered document of deed of adoption dated 5/5/1976, and the learned court has recorded that at the time of adoption, both the parents were present, and the learned sub-registrar has made the required queries and ultimately held that the deed of adoption was in accordance with the. This court finds that the learned first appellate court has not discussed the oral documents at all by coming to the finding. This court also finds that the This court also finds that the learned first appellate court did not even frame any point for determination and primarily based the finding on the basis of the fact that the deed of adoption was a registered document and the presumption under section 16 of the Hindu Adoption and Maintenance Act. This court is of the considered view that the learned first appellate court was duty bound to the learned first appellate court, being the final court of fact and law, was duty bound to consider the evidences based on record and discuss the same. And decide all the issues which were placed before the court on the basis of materials on record. This court is of the considered view that the learned first appellate court has not done the needful as was required under Order 41 Rule 31 of CPC, and accordingly the learned first appellate court has acted in an illegal manner and against the judicial proprietary in not considering and not discussing the evidences on record. Consequently, the substantial question of law is answered in favor of the appellant and in favor of the appellant and against the respondents. However, in view of their aforesaid findings, this court is of the view that the learned first appellate court is required to pass a fresh judgment after considering the materials already available on record and in accordance with the provisions of Order 41 Rule 31 of CPC, after granting an opportunity of hearing to both the parties. Consequently, the judgment passed by the learned first appellate court is hereby set aside. The parties are directed to appear before the learned first appellate court on 10th of November or the successor court on 10th of November 2025 at 11.
बिफोर दिखा दीजिए पहले भी
Exactly.
Exactly. 10th of November 2025 at 11 a.m. Upon their appearance, the learned trial court shall take endeavor to decide the first appeal in accordance with law within a period of, at the earliest, as the suit is of the year 1978. The parties to cooperate. The records be sent back to the concerned court. Photocopy है कि क्या है? Photocopy. Record sent back करने की कोई जरूरत नहीं.
आपके पास ओरिजिनल होगा एलसीआर
नहीं है, सब फोटो कॉपी।
सब फोटोकॉपी आता है.
वहाँ बोलते हैं कि यहाँ आ गया है, सेटमेंट कॉपी निकालने की कोशिश की है।
बाकी आपके दोनों जजमेंट्स को हम डील कर देंगे. एक हमारा
ठीक
बीवी
है
है.
काफी हुआ
ठीक.
काफी हुआ हम लोगों को देखिए फैसला पट्टी का होता है हम लोग का है कि आप सुनती है बढ़िया सुन लेते हैं वी आर कंटेंट
We are obliged for-
इसके बियॉन्ड कुछ नहीं चाहिए
We are obliged for patient hearing.
हाँ जी.